All right, boys and girls, so we're back for another issue of Todd's 2A Talks, and this is another one about Naperville. So a couple of guys have asked me about, I usually wear a hat most of the time. This one is of particular interest to me. It is signed by two heroes and walking pieces of history. I've got Tonto from Benghazi in 13 Hours is a signatory on here, as well as Paul Howe, who was in the Battle of the Black Sea, or what most people know as Black Hawk Down. He was one of the Delta members that was there and was depicted in the movie Black Hawk Down by Michael Forster. So, with this Naperville ordinance about banning the commercial sale of so-called assault weapons, which they define very broadly. That'll be another video as we go through this to see what they refine the definition to. I had a conversation with the city attorney, and he seemed to be woefully unaware about what the case law surrounding the subject matter is, from the Chicago case to what the New York v. Bruen case actually says and does. It's amazing. Well, he's probably going to get a little bit more of an education Tuesday night. Speaking of which, Tuesday night is the city council hearing, the 19th. It opened, the meeting starts at 7 o'clock. If you want to speak, you have to go on to the city's webpage and register to do so by 4 o'clock that afternoon. And then they will call people up in a certain order. It's not difficult. They don't restrict it to residents only. I'll put a link down below. So if you want to come out and speak, show some support for the two gun shops there, and whatever else, this thing may turn into. So we'll put that down below. But the resolution contains 20-some paragraphs in the preamble. I don't want to talk about them. So number 17, whereas in 1994 the U.S. Congress passed the federal assault weapons ban, a United States federal law which prohibited the possession and sale of assault weapons and large capacity magazines, limiting magazines to 10 rounds. Several constitutional challenges were filed against the provisions of the ban, but all were rejected by the courts. The AWB expired in 2004. In accordance with its sunset provisions, and attempts to renew or replace the AWB have been unsuccessful. 2004. That was pre-Heller, when in 2008 the Supreme Court affirmatively and definitively ruled that the Second Amendment contains an explicit right to keep and bear arms to an individual, and was not a collective right. So, the federal ban was upheld by prior lower courts. The Supreme Court turned away any challenges to that. But in post-New York, it is far from a done deal that another federal ban would pass muster. And I don't know who's consulting you guys on what to put in here as far as the preamble, but the 94 ban was not a ban on possession. Every firearm that we had, we could keep. Every magazine we had, we could keep. It was a prohibition on the sale of new firearms that had certain features which were largely cosmetic. So it was not a ban on possession. You guys are just factually wrong. Paragraph 18. Whereas currently 7 states and Washington, D.C. prohibit assault weapons, federal appellate courts have decided 4 cases concerning the Second Amendment and assault weapons. each time reaching the same conclusion that assault weapons bans are constitutional. The D.C. Circuit upheld the District of Columbia's ban in 2011. The Second Circuit upheld New York's ban, New York and Connecticut's laws in 2015. The Seventh Circuit upheld Highland Park ordinance in 2015, and the Fourth Circuit upheld Maryland's ban in 2017. So let's talk about those last two cases. First off, the Maryland case was pending in front of the Supreme Court at the same time Bruen was being decided. And after the court listed its opinion in Bruen, New York State Rifle and Pistol Association v. Bruen, but everybody is shortening it to Bruen these days. The court issued its last day rulings a couple days later, and as part of that were their final orders. In that, they GVR'd 4 gun cases: the Maryland case, the California mag ban, the New Jersey mag ban, and the Hawaii carry case. Now, GVR stands for granted, vacated, remanded. So what happened is there are petitions for cert or certiorari pending in front of the court. The court granted those petitions for cert, and then instead of scheduling briefs and going through the whole litigation route, they vacated the lower court rulings against gun owners. All 4 cases: the semi-auto ban, the 2 mag ban cases, and the carry case out of Hawaii. All the lower court of appeals opinions that went against gun owners were vacated, erased. They no longer stood. They were no longer, citable case law. And with that, they remanded them back to all the lower courts with instructions on see New York. So essentially, it's like, you guys got it wrong, as the court stated several times, and specifically talked about, for the last decade, that lower courts have gotten it wrong, and they sent it back. It is a do-over. Try again. So the Maryland case cited here has no bearing. It was the one case pending up there right now, and the word we've gotten is that Alito would not let another gun case come forward post-McDonald until he knew he had the votes to get it through. Thomas was always a vocal critic of not taking more cases, as is, I think Alito was on one of his dissenting opinions about granting cert. And so with that, they finally got a case, and they got a case that got 6 votes and got gun owners a lot more than just carry. So let's talk about Friedman for a bit, because that came out of Highland Park. It's a case I was involved in, and it was written by then Chief Judge Frank Easterbrook, and the judge, the closing parts of this were, quote, if it has no other effect, Highland Park's ordinance may increase the public's sense of safety. Mass shootings are rare, but they are highly salient, and people tend to overestimate the likelihood of salient events. If a ban on semi-automatic guns and large capacity magazines reduces the perceived risk from a mass shooting and makes the public feel safer, as a result, that's a substantial benefit. Feelings were enough for Justice Easterbrook to say that a law was constitutional. Feelings. That feels more like rational basis. But nonetheless, this and the other part of the decision is an interest balancing approach. No matter how much lipstick Judge Easterbrook tries to put this on the pig with his attempt at text and history, but this is interest balancing. And the problem for these guys is that New York has reset the game board. New York has changed the playing field. So let's dive into New York just a little bit. Quote, we have already recognized in Heller at least one way in which the Second Amendment's historically fixed meaning applies to new circumstances. Its reference to arms does not apply only to those arms in existence in the 18th century. Just as the First Amendment protects modern forms of communications and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Thus, even though the Second Amendment's definition of arms is fixed according to its historical understanding, that general definition covers modern instruments that facilitate armed self-defense. And they cited a stun gun case there. So if you want to talk about modern, well past just things that go bang, stun guns are a modern weapon. And so they clearly meant to cover firearms like ARs, AKs, semi-autos, things like that. And they went on. And so they recognized what all these lower courts had done previously. So if the last decade of Second Amendment litigation has taught this court anything, it is that federal courts tasked with making such difficult empirical judgments regarding firearm regulations under the banner of intermediate scrutiny often defer to the determinations of legislatures. But while that judicial deference to legislative interest balancing is understandable and elsewhere appropriate, it is not deference that the Constitution demands here. The Second Amendment is the very product of an interest balancing by the people, and it surely elevates above all other interests the right of law-abiding, responsible citizens to use arms for self-defense. Heller. It is this balance, struck by the traditions of the American people, that demands our unqualified deference. Well, they go on, because we had this two-step approach that came out of the Seventh Circuit. Despite the popularity of this two-step approach, it is one step too many. Step one of the predominantly framework is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text as informed by history. But Heller and McDonald did not support applying means-end scrutiny in the Second Amendment context. Instead, the government must affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. The test we set forth in Heller and apply today requires courts to assess whether modern firearm regulations are consistent with the Second Amendment's text and historical understanding. The right of the people to keep and bear arms shall not be infringed actually means something now. They put a test forward in this last part, in this last paragraph here. The test that we set forth in Heller and applied today requires the courts to assess whether modern firearms regulations are consistent with the Second Amendment's text and historical understanding. And the text of the Second Amendment that they're talking about, that I threw in here, is the right of the people to keep and bear arms shall not be infringed. They've dealt with the operative clause, the prefatory clause. They've dealt with the prefatory clause, and they said that the militia qualification does not add or subtract to the operative clause of the right of the people. That's it. That's all there is. So this is what New York is going to reset the game on. And it's just amazing that the city attorney did not know about the Illinois Association of Firearm Retailers case that was back in 2014, and it was in response to Chicago's gun shop ban. And this was passed as part of their deal after we won McDonald. But here's the relevant quote from the Illinois Association of Firearm Retailers. The stark reality facing the city each year is thousands of shooting victims and hundreds of murders committed with a gun. But on the other side of this case is another feature of government. Certain fundamental rights are protected by the Constitution, put outside government's reach, including the right to keep and bear arms for self-defense under the Second Amendment. This right must also include the right to acquire a firearm. Although that acquisition right is far from absolute, there are many long-standing restrictions on who may acquire firearms, for example. Felons and the mentally ill have been banned. And there are many restrictions on the sale of firearms, for example, licensing requirements for commercial sales. But that doesn't say that they can ban wholesale categories of firearms from people being able to acquire. Because if we have the right to own them, we have the right to acquire them. So guys, if you've got the time, please make time Tuesday so we can have a good showing at Naperville City Council, because they're going to try this in other places. They're going to be doing more hokey stuff. And I just came across a video from a Naperville City Council person that we're going to put up. They're definitely trying to make some hay here. But, hey, if you like the commentary, if you like the videos, go ahead and hit that like button, hit the subscribe, share this on your social media pages, on Facebook and all that kind of stuff. Get us more likes and views. And as always, frag out.